Wait, I feel like you work from home, right?
I had to run it today. I was actually in Charlotte.
So you're not there. Yeah. I know. Yeah, go ahead. Can you get away or do you have meetings?
Yeah, just let me know when
That's okay.
I'm secretary. I can text. I was like, he's new. He's the secretary now.
My allowance is 500 rounds. And, so
I was very lucky. I was told. So now I got to go to
So, like I said, I had kind of hair outside the leg. I started to hand this out. But I remember Bob came over and you said it was and there were but I figured somebody might be moving it hard, so yeah. But yes. And otherwise,
I think that's well. These are not the people who.
right. But I got to go to yeah.
They're not part of those companies.
I'm so Johnny. I know. I'm one quality of life at my house.
how are you? And it's always, but the damage is always
Jimmy.
This is not here yet.
I'd like to call this meeting of the Summer Zoning Board of Appeals, special meeting of April 23rd, 2026, to order. I would ask the secretary to call the roll.
She probably doesn't know his name, so why?
Well, I'll tell you what. I'll call the roll.
Now who's here?
With all apologies, I'm going to avoid alphabetical order. I'll just go in order. Andy Rocket is absent. Sean Curtis is here.
Yep.
Douglas Stebbins. Tara Moody.
Here.
I'm Ralph Williams, here. And our alternate, Bob Wheeling.
Yes.
And alternate, B.J. Farrow. Absent. Okay. We're going to proceed to an executive session on pending claims and litigation from an appeal from a year ago, Turnberg versus Zoning Board of Appeals, which means we'll be leaving the room for a brief period to discuss this, and then we'll reconvene. Can I have a motion to go into executive session?
Mr. Chairman, if I may, for the record, Carl Landolina. This is a very simple matter. I don't think we're going to need to go into executive session. Obviously, I will if you have some things you'd like to discuss. Either way, I would like you to approve a stipulation which you have in front of you. If you want to discuss it in executive session first.
I have the opportunity to discuss.
Okay, that's fine then.
Okay. So can I have a motion to go into executive session? Mr. Stebbins, do I have a second?
Second.
Mr. Curtis, all in favor?
Aye.
All in favor and unanimous. The board will adjourn and reconvene momentarily. We are adjourning at 6:03. See you soon.
My uncle, he was here in a store years and years and years. So as soon as he got out of his house,
Nope, I'm not that accommodating. Oh, go ahead. Come up with you.
it has yours. Sorry, I'm over in operations.
I think Carol.
I'll get my answer. I just think money. It was cheaper than
So you have to have the signs over that.
Get it down.
Yeah. What do you do for your business?
Well, it's an office. I order stuff.
Probably.
You know, and I have each time. You know,
Oh, good, okay.
we're making money, and you know.
One day, it's very clear.
You got a permit and everything, right?
Wonders what it was.
It's
I see. I'm not
over there. Watch it. Been up there for 5 years. Yeah, so yeah.
My buddy lives up there. So, he's a Harley Davidson. Watch her.
Oh, okay.
Just kidding.
Yeah, you guys are. Next door neighborhood for that. Now, I worked as a secretary.
really badly.
It's like something that worked out.
I think that's even their format too.
Yeah, I told him his plan.
Oh, there's your lot. What's going with right beside the
Exactly, your borders are.
Well, they wanted to keep showing
going to this time, they're going to go. There was an old farmer that they used for potatoes. You know, when the chance of the property,
Back there.
so they used to.
I was looking at it right now with the glasses.
Yeah, I see it.
Another tractor, not a tractor,
No,
a trailer behind it. You know,
and he's
like that. Not 80,000 pound manure truck.
so they right now, you know.
Do I want to see probably not?
Probably not.
Probably not. Yeah, this is great. Hi, how are you? Thanks for coming out again tonight. And then we're for another not cleaning, right?
Where are they gonna go? You know, and
You can see the ducks and the geese on it.
Right around the corner from the Baylor's, which owns Hope Nation. So I said, as a kid,
Trucks. To that thing going across the city. Don't worry. 80,000 gallons. It's such a big window.
Sometimes you get it for like 5 seconds.
Yeah, so like reopening it, but then that name comes up.
Situation just they don't see it.
Oh yeah.
I know. It looks like down right now. I'm not worried about that. I'm not sure.
Something else to
They have an executive session.
Thank you.
Like once a month, and check the wells once.
Bumping it down. It's getting overrun. It is like we'll see every year next to Jen and leaving after the executive session. So if you want to sit next to her,
Okay, thanks, Dory.
I haven't seen legal notice of the result.
I have not. I think they sent us like some legal notices like this for the other meeting. I haven't gotten any for the meetings.
You get one, let me know. You have to use today it's Charles Good running. So you probably have a couple somewhere. If you don't have it's the only time here because kids are running around. My car is
he doesn't shake him away. My son here last meeting. My husband did
I was telling David that, but just one, I think you can feel it. When you have 22 of them, it's just hard to we all had shallow wells. Back in the day. I just put a deep water once.
Any commission last night?
Last year, I just so of course now.
Special. Down here. I don't remember their faces.
One in Summers, one in Hampton. I went down to make feature because they're about a half mile down from 190. Yeah. Okay.
But I don't want to see right. For nothing, exactly.
So they work with you.
had done up because I don't remember that's where they take Vietnam, Korea. I was going to go on that.
Yeah, right here.
You know, it's going to be on TV and Facebook. So, you know,
Right on the corner.
The board will reconvene at in public session at 6:14. The board met in executive session to consider a potential settlement of a previous case before us, Nicholas Turnberg versus the Summers Zoning Board of Appeals. No votes were taken at that time. However, at this time, I will entertain a motion to accept the terms of the stipulation negotiated by the attorneys for the two sides. Do I have some motion? Do I have a second?
Second.
Okay. I would invite the town attorney, Carl Landolina, to make some comments.
Thank you, Mr. Chairman. For the record, Carl Landolina. So as we discussed in the executive session, you have the stipulation before you. Essentially, it will be filed with the court, and there'll be a hearing in front of the Tolland Superior Court. The court must approve this settlement, and after they do that, it'll become a judgment of the court. It'll be somewhat easy to enforce it with a motion for contempt of a court order in the future. And the stipulation provides that Mr. Turnberg can use the property for harvesting timber from the own site and process it there on site, and for whatever he does. I guess he makes firewood and that kind of thing. He won't be allowed to bring in logs or trees or other wood products to the site from off-site and process them there. Our view was that was not an agricultural use, but harvesting timber from your own property and processing it on your own property is a acceptable agricultural use. So based upon that, I would recommend that you do vote to approve it, and it also asks someone to amend the motion so that you would authorize me to execute this document and implement it in the Superior Court.
And for the record, there will be a public notice published of the court hearing?
Yes, the Hartford court requires it in every instance. Some courts don't require it, but I think there's no reason not to. What it'll be published is a notice of that hearing in front of the Tolland Superior Court.
So anybody who had any concerns about the terms of the stipulation would be able to address the court?
It'll be done in open court. It'll be up to the judge as to whether he takes comment, but it's not unusual for the judge to take comment.
I'll entertain an amended motion to further, not simply to authorize the town attorney to proceed with the stipulation. Do I fine with the motioner and the seconder?
Yes.
Okay. Any further discussion among the board? All in favor? Aye. Anybody opposed?
Mr. Curtis, would you just state for the record that you did not participate?
I recused myself from this due to any potential conflicts.
All right.
Okay.
All right. Thank you very much.
Thank you.
Enjoy the rest of your evening.
I'm bound to. Okay. The board will proceed to a public hearing on application ZBA 26-001. Oak Ridge Dairy, LLC, 122 Watchdog Road, Somers, appealing a decision of the zoning enforcement officer regarding storage of manure. Attorney Reiser is here for the dairy. The floor is yours.
Dory Reiser from Grensky Capistella for the record, representing Oak Ridge Dairy in connection with the appeal before you tonight. The appeal, am I on? Sorry.
Thank you. The appeal specifically is of the decision of the ZEO that the placement of tanks on its property to hold digestate, which is a manure product, used for fertilizing the fields, constitutes storage of manure for purposes of the regulations and requires a special permit. Before we dive into our arguments with regard to the appeal, I think a little background both with regard to Oak Ridge Dairy, their farming operations, and their regulation by the state to ensure compliance with the Clean Water Act and generally accepted agricultural principles might answer some questions that we're going to hear raised. I know there have been questions in prior proceedings with the Planning and Zoning Commission and Wetlands Commission, and we would just like to kind of start off on that realm. First, I will say Oak Ridge Dairy is a multi-generational family-owned dairy started by the Baylor family probably a century ago. It is now owned by the Baylors and the Mosiers. We have Seth Baylor and David Mosier here tonight to answer any specific questions if they come up. It's one of the largest, if not the largest, dairy in the Northeast. Their primary operations are in Ellington. However, they own hundreds of acres in Summers and elsewhere in order to grow crop corn for their cows. It's important that they grow their own feed to ensure quality of their dairy products. And one of the farms that they own and grow this corn on is here in town. That's the subject of the appeal at 122 Watchog Road. They've owned this property since the 1970s and been farming it since at least then, and treating the fields with manure since then. So that's my part of the intro. I'm going to turn it over to Brad Schwab, and he's going to talk a little bit about the what he does as a consultant for Oak Ridge Dairy, his role in the process. He is a technical service provider with the NRCS, and that, if you don't know, is the National Resource Conservation Services of the United States Department of Agriculture. He's also a certified crop advisor, and he's been working with Oak Ridge for 6-7 years, I think he said, since about 2019, but he'll speak more about that and about his work with them in preparing and developing various reports and plans that are required with the state of Connecticut. Join me.
Good evening. Thank you for allowing me the time to talk about manure management at Oak Ridge Dairy. So, to clarify, I'm a private consultant, and I'm certified through a program that NRCS, USDA, maintains. That program allows me to act as a subcontractor. They would see my work as equivalent to the work of a federal government employee. Personal about me, I live very close to Buffalo, New York, so a long way from here. And I would add that the county where I live, there are 22 facilities that are permitted similar to Oak Ridge Dairy. So while I'm not from Summers, I know what it is to be the neighbor of a farm. So nutrients on a farm are very important. There's a cycle that I think a lot of people are aware of, but to clarify what that means, when a cow is fed, the nutrients in the feed give her energy. While she's an amazing creature, her stomach is not 100% efficient. So some of the nutrients make it through to the manure. The manure is used the next year to grow the crop. So if you can picture a cycle where feed becomes manure and manure becomes crops and crops become feed, that's a constant thing on any livestock operation. You have nutrients that come onto a farm in the form of fertilizer. You have nutrients that leave the farm every day when milk is sold. So you have inflows and you have outflows, and you have these churning nutrients on a farm. My job is to help the farm to manage those nutrients. So What they would call a nutrient management plan. So a manure management plan would be a piece of that. Fertilizers and manures work together to give the farm the nutrients that it needs. It's important that we keep a farm in balance, because excessive nutrients on a site, they can cause environmental problems, and a farm is really expensive to operate with more nutrients than they need. So our primary goal is to budget our nutrients and to use them as effectively as possible and bring in as few nutrients as possible. So pull back the curtain on what that looks like. Every field that Oak Ridge Dairy operates, we collect a sample of the soil from that field. Every manure source that they produce, we sample that manure. All those samples are sent to a lab. And what the lab does is they tell us the nutrient content of the soil and the manure. We take those results and we couple them with university research. So UConn, Cornell University, the land-grant universities, they study what is the optimal amount of nutrients that are needed to grow a crop. And so at the end of this process is a budget, a nutrient budget that we're saying where is the best place for our nutrients to be on any given day. Our goal with that budget would be to use our manure to the greatest extent possible and to buy as few nutrients in to protect the environment and to be cost effective. There are some challenges because manure is it's not easy to manage. Manure is very high content of water, and this makes it a bulky, dilute product. So if the research shows that we need a whole lot of manure to meet a crop's need, that might not be feasible unless the field can absorb and retain that amount of manure. So to mitigate this concern with the process, there are university models, they call them indices, that gauge the risk of loss from any given field. So if a field is steep and near a stream, that's a risky field. If it's flat and far from a stream, that's a lower risk field. It's not to say that high risk means pollution and low risk means no pollution, but that's what guides us when we develop a specific prescribed rate for every field on the farm. Field number 1 is different than field number 2. It can vary based on soil test. It can vary based on what crop we want to grow. So I think what I'd like to impart on you is that there's science and there's math and there's budgeting in this. And the logical next question might be, well, who provides the oversight? DEP issued the farm what they call a CAFO permit. A CAFO permit requires that a farm have a nutrient management plan that is written by somebody who is certified. When the permit is applied for, the farm volunteers to allow DEP unhindered access to these records of what is done any day that DEP asks for them. So when Oak Ridge Dairy operates, they know DEP could show up today or they could show up tomorrow. At the very least, they file an annual compliance report, and that report tells DEP once a year how much is produced, how much manure is produced, where was it used, what was the allowable rate, and what was the actual rate. How many cows do we have? How many acres support those cows? So there is the opportunity for complete transparency. DEP could be at the farm on any day they want. So I think that's all I need to say. There were just, managing manure this way by recycling it in land application. And I say recycle, there is no disposal of manure. We're recycling manure. This is a common way through a nutrient management plan for a farm to operate countrywide. It's a generally accepted agricultural practice to recycle your manure. I would say with regard to the 360 rain system, which is part of this discussion, farms constantly evolve. So you could equate conventional manure spreading versus 360 rain to a light switch on the wall or a smart home. You could throw the light switch and the light comes on, or you can tell Alexa to turn your lights on. At the end of the day, the light is on. Same result. If manure is applied with the 360 rain system, there is no higher rate that comes from that. The recipe for each field is exactly the same. And the last thing that I'll say is that, you may see the farm apply manure to the same field twice in the same year. And I think it'd be common for people who don't understand this process to think the farm's doubling up on that field. The reality is there's only one prescribed rate. And to split applications, is the terminology that we use, is a lot better environmentally. 2 small doses is better than 1 big dose. And so, it's an example of something that might be counterintuitive to what a neighbor might think, that, boy, they've been there twice. That's a good thing. And that's all I had prepared.
Don't go anywhere because I want you to chime in on this, but I really liked your analogy of the smart home. And because you alluded to the Rain 360, part of the application that's the appeal that's before you, these tanks, if you will, that are there, have to do with feeding the Rain 360 robotic fertilizing device. And what that is instead of just trucking manure, solid or liquid, to the field and generally broadcasting it out, it is through a hose. This liquid manure is piped or fed into the Rain 360 robotic device, as well as a water source. We have a well on the site. So the liquid digestate, which is manure, and water will both be piped in at a certain rate and a certain consistency based on Brad's recipe, if you will, and then broadcast on the field, but in a much more controlled manner. The Rain 360 as a robotic device is, correct me if I'm wrong, is GPS controlled, and it will go up and down the fields, and it will deliver on a consistent, measured basis the irrigation and nutrients that the crops need to produce. And rather than doing what was historically done, truckloads in throughout the course of the year of manure, dumping it on the ground and then spreading it in bulk in spring and fall, this will be a more measured, controlled application during the growing season. And that's what these tanks will facilitate. And then we'll talk a little bit about that.
If I may interrupt.
Yes.
This is all very informative. Mm-hmm. But the purpose of the hearing is the question of whether or not the zoning enforcement officer correctly concluded that the tanks that you propose to put on the property are storage tanks, and also whether, as you contend in your appeal, that the of right agricultural use encompasses this. I would, given the number of people here, the amount of time it's going to take, I would be grateful if we could home in on those particular issues.
The reason I wanted to start with this is because I think understanding the usage of the tanks will help you then determine whether or not they fall within the regulatory requirements for storage of manure. So storage of manure we're going to talk about at length. But again, the tanks are used as a means of feeding the fertilizing robot. Okay? So with that introduction, we will get right into it. Thank you. You're welcome to stay or wherever you're most comfortable. So now that we've talked about the review process, the development of a plan process, even the state the state regulatory process. I don't mean to tell you that to imply that the town can't also regulate. The town can regulate, but if you do regulate, it's got to be grounded in your regulations. And for purposes of tonight, that's got to be grounded in your zoning regulations. So let's start with your zoning regulations. Now, what's being passed around right now is just some relevant excerpts from your current zoning regulations. The first page you've got here shows as an ZPNR, zoning permit not required, so permitted use as of right, farming and agriculture in all residential zones. Okay? So, what is farming and agriculture? Well, for that, I would ask you to turn to the next page where your regulations define agriculture. And the very first thing under agriculture is cultivation of the soil. That means fertilizing it for crop production. It's the applicant's position that all activities involving fertilizing the land are permitted as of right under your zoning regulations. Now, that includes structures, because agriculture also includes some buildings and structures used in connection with agriculture, and structures are specifically defined in the regulations as including storage tanks. So, again, I would submit that a permitted use as of right in town, in every residential zone, is agriculture, and that implicit in that is cultivation of the soil. Your zoning enforcement officer has determined that the storage of manure is a special permit, and it applies to these tanks. Well, we think that's inconsistent with your regulation that allows for farming, including cultivation of soil, amending the soil so it properly supports plant growth, is a permitted as of use right. Now, let me just make sure there's nothing else in here I wanted to check. Okay. So in this handout, it's your regulatory definition of agriculture, the state statute definition of agriculture, which is virtually the same. And then there's just a print out of what's encompassed in cultivation of soil. And that includes, again, fertilizing. It includes amending soil in order to allow for proper crop production. I'm not going to read through the whole thing, but I think we all know, without needing to read this, what's included in cultivation of soil. And common sense shows that fertilizing crops is part of cultivating the soil. Now, your regulations have to be viewed as a whole, and in a way so that there's, you can reconcile any potential conflicts. So how can we have one provision in your regulations that say agriculture is permitted as of right, and another one that says you need a special permit to have manure stored on your property? Those, to me, sound in conflict. Let me give you something else. Now, this is just a brief legal memorandum on principles of statutory construction. And as I just said, Connecticut courts presume that the legislature, or for your purposes, this body, when they adopt regulations, intend a harmonious scheme. They don't intend that you would create regulations with an internal conflict and that can't be reconciled. So you have to look at all of your regulations in general to see if you can reconcile them and have them so that both sections mean what they're intended to mean, and try to avoid the conflict. So having said that, I did a deep dive into your regulations to see what exactly this storage of manure special permit was intended to address. And in my opinion, this section of the regulations that we're cited to have to comply with was never intended to apply to farms fertilizing their fields. It was adopted in order to address manure associated with stabling and keeping of horses and ponies on a property. So what I did is I went back through the whole regulatory history, back to 1960, to see what the regulations were with regard to storage of manure and how we got here. And what you have in front of you is that history. So in 1960, you can see there's nothing in the regulations that addresses storing manure. Farms are permitted as of right, and the only thing that's in the regulations is a restriction on how far a structure housing animals has to be from the road or a neighboring property. In 1977, storage of manure and fertilizers on a farm were addressed, and they said they had to be over 100 feet from the property line. But there was still no permit requirement, okay? So there's no permit requirement, but it's the first time we see that manure has to be stored a certain distance from a property line, but still permitted. Next version is in 1984. And here, for the first time, we see manure storage addressed in the context of groundwater protection. It sets forth buffers to water courses. But other than that, with regard to farms, it says farms are permitted, provided that the storage of fertilizer and manure shall be at least 100 feet from a property line. So again, permitted as of right, just setbacks on where it's stored. It's not until 1990 where we see a little bit of a change. In 1990, we still have regulations that address storage of manure with regard to groundwater. But here, for the first time, we have, if you go to what says on the top of this one, page 49, the section having to do with horses and ponies. And it allows horses and ponies by special use permit. And it says that areas of concentrated storage of waste shall be not less than 200 feet from a street line and not less than 200 feet from a side and rear property line. And then you have a table on the next page that talks about those buildings housing animals. And it's where we see for the first time the 2 cubic yard requirement that made its way into your current regulations. It says that it's permitted, but you can't exceed 2 cubic yards. Again, this has to do with buildings housing animals, and specifically in the horses and ponies section. In 2000, it's the same thing. I just gave you a copy of that. There's really nothing different than what we saw in 1990. And the reason I'm taking you through this, because I do believe that 1990 version was the predecessor of what's in your current regulations. And your current regulations, you have the last 2 pages of this attachment here, where we see manure storage is allowed as an accessory use in a residential zone. Up to 2 cubic yards is permitted as of right. And that tracks with what we saw adopted initially in 1990. Then it goes on to allow for additional storage if you're a certain distance from a property line, and then over 16 cubic yards if you get a special permit. I think what's interesting also is the placement of this regulation in this section within the regulations itself, because it's directly under the building housing animals section, which just to me goes along with the premise that the whole purpose of this manure storage regulation, the intent was to deal with manure generated from housing animals on the property, such as horses and ponies, which first appeared in your regulations in 1990. This regulation in particular, which your zoning officer says requires us to come to you for a special permit, was never intended to apply to a farm and their use of manure for fertilizing the fields. It was intended to apply to how you deal with manure from animals kept on a farm. And I think further evidence of that is the fact that we did some investigation and we could not find one permit issued to a farm for manure storage in connection with fertilizing their fields. It's not something that has ever been required of a farm operator in town before. And this town has a history of 300 years of farming. So, now granted, the regulation is much more recent than that, but it's very unusual why it would be applied in the first instance, the first time, for these field fertilization methods. So, our contention is that this regulation is wholly inapplicable to the process that we just described to you. The reason we need these tanks to feed the robotic fertilizer in order to fertilize our fields, to cultivate the soil, a permitted agricultural use. We also don't believe that this regulation is applicable because it's specifically listed as an accessory use, right? It says it's in the table of permitted accessory uses. You can have manure storage as an accessory use. This is by no means, accessory to the farm. It is not incidental. It's not subordinate. It is critical to the farming operations. It is one of the principal farming operations. It is, per your definitions, the essence of farming, cultivation of soil. It's the principal use. It's not an accessory use. And therefore, this regulation, we believe, is wholly inapplicable to what my client is proposing to use these tanks for. Now, I recognize that you have an opinion from your town attorney, who's here tonight, that the transfer tanks fall under this regulation, but based on everything that I've said already and that I will continue to say, I do hope that he will reconsider that. And I hope you will reconsider it, because I'll remind you that ultimately the interpretation of your regulations and how this should be applied is up to you. They're your regulations. Your town attorney, in the opinion, even agreed that our arguments are not unreasonable. So it's really up to you to decide, based on everything we're telling you about how these tanks will be used, what their purposes are. That's all relevant to your interpretation of whether this is storage of manure for purposes of that regulation. And I think, based on the history of the regulation, I think it's a stretch to get there. But not just that. I think it's also, again, a very integral part of the permitted use, permitted as of right. And it's not an accessory use. It's not incidental storage of manure. This is critical for the operations of the farm. So that's for you to think about. Now, I would be remiss if I just ended there, okay? I have to assume that you might not be completely on board with everything I've said so far. So I'm going to make a couple of alternative arguments. So even if you say, no, you know what, I think this regulation applies, I'm going to make two more arguments. I don't believe, and we don't believe, that this is storage. It's not storage intended to house and maintain something for an indefinite location at a site. It's really more similar to transportation. It's getting something from point A to point B. And it's similar to the trucks that bring the digestate to the site. We have to get from point A to point B. We have to get from where the digestate is in Ellington over to the field that we need to apply it on. And then we have to go further. We have to get it from there into the fertilizing mechanism, the Rain 360. And the only way to do that is via some kind of conveyance system. So you've got to get the liquid into... we have to get the liquid...
I don't have the ability to control it. I can help you turn off your phone.
It's okay. Thank you. So we look at this as a conveyance mechanism similar to trucking it to the site. We have a piece of equipment, which is the tank, through which we transfer the digestate into the Rain 360, and then it's broadcast on the fields. Now, excuse me. Your regulations don't define storage. And in the absence of a definition in regulations, it says looked to the state building code, looked to the Connecticut general statutes. Neither of those were helpful in this regard. But then it also says, look to Black's Law Dictionary. So I apologize for the version of Black's Law Dictionary. This actually is my Black's Law Dictionary from when I was in law school 30 years ago. But it's still the same definition, I believe. Oh, sorry. And how Black's Law Dictionary defines to store, so the verb to store, is to keep merchandise or something for safe custody, to be delivered in the same condition as when it was received, where the safe keeping is the principal object of deposit and not the consumption or sale. This contemplates keeping something for a period of time. The safe keeping of it is the principal object. That's not, and consumption is not. That's not. We are consuming, if you will, this digestate immediately. The digestate gets trucked to the site. It goes into the transfer tank. Starting at, let's say, 7 in the morning, the trucks come to the site, they fill it. At 7:30, we turn a switch, and the irrigation starts. So it comes in, and it goes out. The purpose is not to hold it there for a period of time. In fact, we empty it through the day, and it gets filled up again the next day. So I don't believe this constitutes storage. I think, based on the Black's Law Dictionary, our purposes for this transfer take, again, is a means of conveyance, totally different from, storing something indefinitely. We're just trying to get something from point A to point B. Again, there's a constant coming and going. Now, the next alternative argument I'll make is this regulation, if you were to entertain the fact that perhaps it applied here, is inapplicable because we're grandfathered. We're protected as a non-conforming use. As I noted at the beginning of the hearing, my clients have owned and managed these fields for crop production since the 1970s, and the corn production has involved the use of fertilizers and manure for that purpose since then. And before even then, it was used as a potato farm. So I imagine there was some type of cultivation of the soil going on at that point as well. So, but our only personal experiences for the last 50 years, they've been bringing manure to this site and dumping it on the site and spreading it on the site for 50 years. That is a pre-existing non-conforming use, bringing and dumping. What they used to do is they just used to truck it in all year round, truck it in, dump it on the site, on the ground, not in something, not in a plastic liner, just dump it on the ground throughout the fields and then spread it. And they'd do that in the fall and in the spring. They'd heavy load it, right? They'd load it up to really get the nutrients into the ground. That's what historically was being done. So that, at least at a minimum, the spreading of manure on these fields is grandfathered. So now the question comes, is it different now because we're applying digestate? And I would say it's no different. Digestate is manure, right? We're applying the exact same concentrations of nutrients. As Brad Schwab said, the recipe's the same. So before, when we were bringing tons and tons of cow manure and dumping it on the site, now we're trucking it in during the growing season, not all year round, just during the growing season, filling the tank is emptying, and then it gets filled again. And that's going to be a daily process as the liquid manure now is broadcast onto the field through this Rain 360. It is a modernized way of doing things. It's an improved way of doing things, but essentially it's the same thing. We're not doing anything different than what we used to do. What I'm handing out now is a memorandum having to do with how you deal with non-conforming uses when there's some changes. And intensifications, specifically, of a non-conforming use, so just more of the same, is permitted. So the fact that, we used to use solid manure to dump on the site. Now the fact that we're doing it slightly different with liquid manure, and maybe, the volume, because it's when you're comparing solid versus liquid, the volumes are are different. More of the same is permitted, and the case law supports that, as long as there's no change in the essential character. So what's really important is to look at it from a qualitative, not a quantitative perspective. Quantity doesn't matter if we're bringing 10 tons of poo or 100 tons of poo. Okay, what matters is the character of what we're doing, and is fertilizing the field with a liquid digestate manure product instead of bringing to the field and fertilizing it with solid manure, is that characteristically different? This memo gives you what's called the Zacks factors, which are 3 factors that you're supposed to review to determine if it's permissible or if it's an illegal expansion of the nonconforming use. The first factor is you have to look at the extent to which the current use reflects the nature and purpose of the original use. Well, the current use is to fertilize the fields with manure, and the original use was to fertilize the fields with manure. I would say those are the exact same. The next factor is you have to look at any differences in the character, nature, and kind of the use involved. Okay, the use involved is now we are, instead of storing, if you will, tons and tons of solid manure on the fields, we are storing, albeit very temporarily, because we don't consider it storage, we consider it a conveyance mechanism, liquid manure, the digestate, in a tank. And substantially, those are the same thing. We're talking about solid manure and liquid manure. Solid dumped directly on the ground throughout the fields and just in piles until it's spread, and liquid being held in the container until it's immediately fed into the fertilizing Rain 360 unit. And the last component is you have to look and see whether there's a substantial difference in effect on the neighborhood resulting from the difference in the activities. Well, I would say no. I mean, we're applying manure. So if there's any odor attendant to solid manure, you've got the same odor attendant to liquid manure. We have the same nutrient impacts on the ground, right? Because we have the same formula or recipe that we're applying. And if anything, I would say an improvement is on truck traffic. So I would say it's a beneficial impact on the neighborhood, because doing it with the Rain 360, we'll probably be looking at about 10 truckloads a day during the growing season. Whereas when we were dumping manure on the site, we were probably looking at 120 truckloads a day for 2 weeks in the spring and 2 weeks in the fall. So you had a ton of truck traffic 2 weeks in the spring and 2 weeks in the fall. Now you'll have minor traffic through the growing season, and then that's it. So I think, the effect on the neighborhood will be lessened, if anything, with regard to this improved, modernized way of fertilizing the fields. Okay. So again, the character's not changing. We are really just changing how we're applying the fertilizer. That's really all we're talking about here. Instead of applying it in solid form and broadcasting it across the site, we are now bringing it to the site and feeding it into the soil in liquid form via this necessary transfer tank. Again, it's no different than trucking it to the site, point A to point B, then it goes from point C to D, I suppose, to get it into the facility for spraying it on the field. So I know I said a lot there. I do have more to say, but I really think that I can hold the remainder of my comments until we hear from you. From the public. We do strongly stand behind the position that this is a permitted as of use right, a principal use of the property being agriculture and cultivation of the soil, which includes all means necessary for fertilizing the soil, which includes the storage tanks, because structures are permitted as agriculture. I gave you some alternative considerations to review as well. And if anyone has any specific questions for me at this point, I would be very happy to entertain them. Or if you have any questions about the operation out there, or further detail on how these tanks will operate, then we can certainly answer that as well.
Any members of the board have any questions for the attorney?
Yes.
When you apply the liquid manure with the 360 range,
Is your light on? Green light.
does that give it less odor than when you bring on the solids?
I just see my clients nodding yes. I don't have personal knowledge of that, but they say yes. So the liquid manure is less odorous than solid.
So when you apply the solids,
Excuse me.
so when you apply the solids, you got to go out and then you got to plow the solids, and then get your clean and your heroin and all that stuff. So with this 360 machine, you put it in. Do you have to plow, or do you plow it? You just plow it to plant.
Why don't one of you come up and speak into the microphone and introduce yourself?
Hi, I'm David Moser with the Oak Ridge operations team. So the Rain 360 is a great question. Plowing of the field is eliminated. We put the manure on right at the roots of the corn with it's called a Y drop system. So it drops it on or dribbles it on right at the base, and that the leaves and the foliage of the corn help reduce that odor. Where when we put on the spring, it's sprayed on. It can volatilize more. So we want it to not volatilize because, back to Brad's point, that captures the nutrients and keeps them with the corn.
One question I'd have, the tanks you're using, are they capable of storage?
The tanks that we're using
Are they capable of storage?
Yes, they're designed specifically for storage, and they. I have a spec sheet on them. Would you like me to submit them?
You're welcome to.
You want to address the tanks, Judy?
Yes.
Bear with me. I only have one copy, I'm sorry, but it's flat top corrugated wall tank system for storing liquids with confidence, and I will hand that in.
Okay. So they are capable of storage. That's all.
Yeah.
That's one thing.
Yeah.
Steel.
Can you just refresh me the definition of digestate versus the definition of manure?
I will.
I can give you the farmer definition.
Yeah, great. Thank you.
So manure comes directly from the cow. We clean the manure up inside of our facility at Oak Ridge, and we send it to a digester. That digester captures the methane gases from that manure and turns it into natural gas. In our facility in Ellington, fun fact, it's about 800 vehicles worth of gas a day that we're capturing and returning to the natural gas pipeline. After it goes through that process, we refer to it as digestate. So we as farmers call it manure on both sides. Politically correct maybe is manure before, digestate after. And a digester is simply a vessel that holds manure for 20 days, heats it up to 100 degrees, and that makes the methane separate from it. They take the methane and turn it into gas. Dory probably has it better.
No, that's a great explanation. The only thing I will expand on is for definitions in order to determine compliance with the Clean Water Act. Manure is defined as urine and feces excreted from livestock and other materials commingled with urine and feces, including bedding and compost. And digestate means solid and liquid material remaining after the anaerobic digestion, which is the process that you just explained.
Any other questions from the board?
I have a question. Can you repeat that part about the trucks? How many trucks come in and out now, and how many trucks come in and out later?
Mm-hmm. Yes, what I had said was
Kind of like went through it there.
Yep. There'll be about 10 truckloads a day with this type of application, with using the right. Well, no, not year round, just during the crop season.
during the cropping season.
Yep.
Okay.
Yes.
And before it was 200 in that.
No, it was about 120 truckloads a day in for a 2-week period in the spring and in the fall.
Only half of which drove by my house.
So back to Brad's comment and why Brad was here. Corn needs so much fertilizer, so much manure, so many nutrients. That has to be brought to the cornfield. This application method that we're proposing spreads that application method out because we can feed it to the corn crop while it's growing. That's the magic of the Rain 360. Without the Rain 360, you have to put it on in the spring before the corn grows, so you have to get it all there at one time. After the corn comes off, you can put more on in the fall. Brad's point, it's the same amount. That doesn't change. The amount of manure coming does not change. The corn crop needs X amount. We need, the Rain 360 allows us to put it on while it's growing, so that spreads out the window of which we can put it on. Does that help?
I just have one follow-up question since you're here. So historically, as we've been taken through, your family, the operation has over the years spread manure here, which in I'm assuming the definition that you're just giving me, manure versus digestate, all of that gas, if you will, was packed within that. Is there an environmental benefit now of the digestate without the gases in it versus the manure that you used to spread in these fields?
Yes, they're so nutrient-wise, it's very similar. Odor-wise, the odor is less with digestate.
Thank you.
Yep.
Any other questions from the board? No. Okay, I'd like to let the zoning enforcement officer, since it's her order that's under dispute.
Thank you.
Have a chance to speak now.
Jennifer Roy, zoning enforcement officer for the town of Summers. For the record, I was going to give you for an exhibit the page in the zoning regs, but Dory gave it to you under accessory uses, and that section is agricultural related, and then it specifically breaks out to manure storage. And I just want to clarify, and I will let Attorney Ziska address the ZBA on how to proceed, but there is no order issued for manure, digestate, or whatever. The order was issued under the legal opinion that those tanks are storage bins and need a special use permit. And our regulations say it should be 100 feet off the road. No question about anything they're using. That's not what this is. This is for my letter stating that they need to get a special use permit to put the bins on the property. Period. So whether it smells or not, whether it's liquid or, I am not questioning or saying that they need permission to farm. Period. So unless you have questions, for me, you were provided the legal opinion from Attorney Ziska, and I'll let him address what he wants to. But you're really just determining, do you consider them storage bins? And if so, they need a special use permit per our regulations.
Review, Council.
Okay, Dory, you said you passed this out?
We have. We got it in our package.
All right, and I have certain sections of the regulations that I wanted you to have too. I know you've already gotten copies of these, but I might as well have those distributed just to make it easier. Dory, do you have a copy of my opinion?
I do. Thank you.
Okay. John, do you? Your opinion, yes. You have it, okay. All right.
If you could just introduce yourself to the public.
I'm sorry. Thank you, Mr. Keeney. My name is Michael Ziska. I am Special Land Use Counsel for the town of Summers. I advise the land use agencies and officials of the town on request about land use related legal issues. Here's the issue in a nutshell, and I think the board has already recognized this, or at least a couple of the members have already specifically recognized this. Section 3.3C5D requires a special use permit for property in the residential district for, quote, manure storage in accordance with generally accepted agricultural practices, and it says if more than 16 cubic yards or if between 2 cubic yards and 16 cubic yards and stored less than 100 feet from any property line. So that's the regulation. If you are storing more than 16 cubic yards of manure, you need a special use permit. That's what we're dealing with here. I note that Section 4.4 has a similar regulation for the business zone. So again, it's correct to say the issue here is not whether this is a good idea. This could very well be the best idea in the world. But we think that's an issue that, under the regulations, belongs before the Planning and Zoning Commission. That's what the special use permit regulations are for. So I know the public doesn't have my opinion letter, so I want to give, and pardon me for this, I rarely do this, but because of the number of people here, let me take just a couple of minutes to read the heart of this opinion letter so you'll see what my logic is in interpreting this regulation. First of all, I agree with Attorney Reiser. She's absolutely correct in saying you try to look at the regulations as a whole. You don't look at them in isolation. You try to see whether or not regulations that seem to conflict can be found to have a happy median zone, a place where they can both operate well. And so I agree fully with that. And so I start looking at Section 7.12, entitled Groundwater Protection, and that refers repeatedly to quote-unquote storage tanks. Subsection B1 of that section deals with storage tanks intended to distribute fuel oil to residences, including basement and above-ground tanks. And so, similar to the tanks that Oak Ridge is proposing, fuel oil tanks are not designed to hold fuel oil forever. That's not their main purpose. Their main purpose is to provide heating oil to the heating equipment in the home. And so, although the distribution time may be longer for a fuel oil tank, hopefully it's longer in this, the winter that we had, although the distribution time may be longer, the point is they're designed to hold the material for as long as is necessary. That's why they're called storage tanks. So the fact that Oak Ridge tanks might not have a lot of holding time doesn't detract from the fact that, similar to an oil storage tank, they're storage tanks. That's what they are. And I would note that the regulations provide no basis for distinguishing among temporary storage tanks based on the amount of time of storage. And that's where part of the problem comes in. If you draw an arbitrary line, it can't help but be arbitrary. Where do you draw that line? If the stuff is held for a day, is that the cutoff point, or is it 2 days, or is it a week, or is it a month? What is the cutoff time? Well, the regulations don't provide any sort of a cutoff time, and so, in my view, you can't put one in there. You can't shoehorn one in there. The courts have said that you can't imply that certain language is in the regulations if it in fact isn't in there. You don't interpolate new language into the regulations. There is no dividing line between temporary storage and regular storage. So I don't think the board can do that. And we'd also note subsection B4 of section 7.12 refers to new and enlarged manure storage sites, new and enlarged manure storage sites. So it may be better. It could very well be better. I don't know that, and I certainly have respect for the people from Oak Ridge making that testimony, and I'm not questioning that. But it is a new system. The storage tanks are new. They haven't been there before. This is a new system. Subsection B5 talks about any above-ground storage tank. This is an above-ground storage tank. So since the purpose of Section 7.12 is groundwater protection, and since the possibility of a spill is not dependent on how quickly any shipment of material may be dispersed, it's difficult to believe that the speed of distribution was intended to limit the meaning of storage tank. I mean, you could bring a storage, you could fill a storage tank, it could have a crack in it, a crack that developed at some point that nobody's aware of. You fill it, and all of a sudden it blows. And so the material was in there for, literally an hour or less, and now it's all over the field. I think that's what 7.12 is trying to address. 7.12, I think, putting it in the special use permit section recognizes that there may be these kinds of things that can happen, and so the Planning and Zoning Commission would want to know, okay, where are the tanks going to be? What's in the area? Are there wells in the area? Is there anything that could be particularly damaged? Is there a better place on the site to put these tanks? So I think this was intended to just say, we want to take a look at it and just make sure that if you are storing, that it's stored in the best location for that, or in a reasonable location for that. Doesn't mean it can't be done. It just, they want to see where you're going to do it. And all of these details about how long it's going to be stored would feed into that, whether or not it's an appropriate use. So we also note that the regulations do not define storage. They define the term storage trailer, for instance, as a vehicle without means of propulsion which can be used for hauling or storing of materials and is capable of being readily moved by a tractor or other vehicle. So just like one of you gentlemen pointed out earlier, this can be used for long-term storage. And storage trailer, since the regulations are saying storage trailer just has to be a vehicle that can be used for storage, by the same token, we see no reason to distinguish that with storage tanks. They're capable of use for storage. So that's our argument in a nutshell, that this falls into the category of a storage tank. And I want to address then Attorney Reiser's other arguments. The first argument is that the history of the regulation shows an intent to deal with horses and ponies, not general fertilization. Actually, this is the first time I've seen that history. But even looking at that history the first time, I think the exact opposite argument could be made. Because usually when the courts interpret statutes or regulations, they say we try not to consider any word or phrase as being insignificant. We always try to assume that when a change is made, something significant is intended. And so what I would say is to the extent that in the past, manure storage was tied to horses and ponies, and now it's not. The intent that I think should be read from that is the Planning and Zoning Commission was now broadening the category. It used to be, perhaps, limited to horses and ponies. That was the intent. And now, with additional environmental concerns, it was broadened. The limitation to horses and ponies is not taken out. And I would also point out that if you look at Section 3.3 that I gave you, subpart 4, C4, shows horses and ponies for pleasure only, horses and ponies for commercial purposes. The point being, when the Planning and Zoning Commission wanted to address horses and ponies specifically, they knew how to do it. And they didn't do it for manure storage. So I think the history points out just the opposite result. Now, the argument that it's allowed because it's agriculture, the same argument could be made theoretically for heating oil storage tanks in residential homes. You can see that 7-12 has specific regulations for oil storage tanks in homes. Well, if oil storage tanks are a necessary part of residential use, and residential uses are allowed as of right, why bother having a special regulation about heating oil tanks? What's the point? You can't regulate them anyway, so why say anything about them? The point is, that's not a valid argument. You can allow a principal use as of right and still limit the extent of accessory uses on that. You don't have to allow all of the accessory uses to the same extent that you would allow the principal use. Attorney Reiser says this is a principal use. The storage tanks are a principal use. It's not an accessory use. I would disagree. I think the principal use is a farm or agriculture. Agriculture is the principal use, but specific aspects of that agriculture, where a shed can go, where storage tanks can go, those functional parts of the farm can be separately regulated and have been separately regulated. And so I think that's all the Zoning Commission did when it created these regulations. Now, finally, with regard to the grandfathering argument, this is the first time that we've heard Oak Ridge actually address that. We were before the Zoning Commission before, and Oak Ridge was before the Zoning Commission before, addressing certain arguments with regard to whether or not what they were proposing constituted storage. And I hadn't heard the grandfathering argument before. In my opinion letter, I specifically said I'm not addressing grandfathering because I hadn't heard any arguments about grandfathering, so there was nothing for me to address. So this is the first time I'm hearing the grandfathering argument. And in a way, I'm sort of sorry it's brought up in this fashion, because I haven't heard enough to say to the board, I think a valid grandfathering argument has been made. What we have heard was manure has been brought onto the property before and spread out, but no details of that. We've heard that it used to be solid manure, and now we've got liquid manure. Is that a substantial difference? Arguably it is. We didn't have storage tanks before, now we've got storage tanks. I agree with Attorney Reiser. The comments she made about non-conforming uses being able to have improved instrumentalities is correct. But all of that, I think, has to be viewed in the context of what the regulations said. And in here, we have regulations that specifically talked about the placement of storage tanks. Specifically, we're looking for details about where the storage tanks would go. So if a special permit had been issued for manure storage in the past, and it was going to be in a different area now, that could require a new special use permit. Similarly, the fact that manure storage of a different type and in different locations and spread differently used to be occurring on the site or has been occurring on the site for many years does not mean that storage of digestate in tanks for a different system is part of an improved instrumentality as compared to Section 7.12 and Section 3.3. So, although I did acknowledge in my opinion letter that grandfathering was something that I had not addressed because I hadn't heard anything about it, my advice to the board at this point is I don't think under the regulations that this is a similar enough use because of the language of the regulations looking for detail on these tanks. I don't think this is a similar enough use to be considered just intensification of the use. I think this would be a different type of manure storage that has to be reviewed differently. So to conclude, again, I will just reiterate, this has nothing whatsoever to do with the quality of what they're trying to do, the wisdom of what they're trying to do, the benefits, frankly, of what they're trying to do. It sounds to me, this is not a legal opinion, it sounds to me like this could be a good idea. But I think that's an issue for the Planning and Zoning Commission. Thank you.
Any board members have any questions for Attorney Siskin? Okay. I think at this point I'm going to open the floor to the public. I want to set a few ground rules. I don't care that manure smells. That's not before the board tonight. I also don't care that you think they should stop spreading manure. They're going to spread manure. That part is of right. The question before us is specifically whether these tanks are covered by the zoning regulations, which, let me also point out, do not forbid them, but require a special use permit for them. And if we stray too far from that, or if we get too repetitive, I'm going to ask people to curtail their remarks. That being said, it looks like Attorney Parks is quite eager to speak.
Yes, I'm John Parks, and I'm here on behalf of.
Green light. Good evening. My name's John Parks, and I'm here on behalf of a number of residents. I'm an attorney in Enfield, Connecticut, who are concerned about this. I also have prepared a handout, and the idea of it is to shorten my remarks and focus and organize precisely the question that you asked. And I'm going to start out with agricultural structures are not exempt from your zoning regulations, okay? And I have law to that effect in the back of this notebook. But what I'm attempting to do in this notebook is to show the board how we got to where we are today, okay? On January 1st, January 7th of 2026, the Conservation Commission reviewed an application by Oak Ridge to cross the wetlands. It wasn't on the agenda, and that's covered on pages on page 1 of my my handout, and it has a plan, and the plan for the crossing of a wetlands shows 4 storage tanks. I also submitted this to the Conservation Commission, and I only have 1 copy, and I'd like to say that for the members of the public that are here that want to see anything that I'm handing out, I'm going to have this pad. If you leave me your email, I will email you what I've just handed to the commission. Before the Conservation Commission, I also prepared a notebook, and that notebook details a lot more specifics relative to the plan and the placement of these containers. And Attorney Zitska, and everybody hasn't mentioned this, but he mentioned that the regulation regulates 16 cubic yards. What we're talking about is 400 cubic yards. And all we're asking is that the commission, the Planning and Zoning Commission, have the ability to look at that, and I agree with Attorney Zitska that they can review details about this type of use relative to people's wells, the wetlands, the water courses. On February 4th, the Conservation Commission discussed this again, and that's on page 9 of my application, on my notebook, and there were concerns about these 4 containers. And on February 12th, these same plans went before the Planning and Zoning Commission. That's on page 10 of my handout, and they are the ones that requested the legal opinion. Attorney Zitska has already addressed his opinion, which occurred on, which was written on February 25th. On March 4th, the Conservation Commission held a public hearing, which is the hearing that I did that black-colored notebook at. And on the 10th, this ZBA appeal was filed. That's on page 16 in your notebook. And then on April 8th, the Conservation Commission approved the wetland crossing but did not approve the manure storage containers. And in that black notebook that I submitted to the Conservation Commission, there was a opinion from a public engineer which was not refuted that said in the event of a leak in that, and we're talking about 80,000 gallons, in the event of a leak because of the location per the plant, upgrading of both the wetland and the water course, that would infiltrate both the wetlands and the water course. That's not contested and unfortunately wasn't addressed by Oak Ridge at the hearing, and I believe that's why the Conservation Commission exempted that. That's on page 17 and 18 of the plan. The next day, and one of the concerns and one of the things regulated by zoning regulations, and agricultural structures are not exempt from zoning regulations, is safety. The next day, on April 9th, the day after the Conservation Commission, one of these large farm vehicles owned by Oak Ridge hit a telephone pole, knocking the pole and the wires into Pioneer Heights. There's a copy of that on page 23. It's an article in the Patch. And then on page 7, you'll see that picture of that pole that was damaged. And these are legitimate concerns that a planning and zoning review can look at as to what are the safeguards for the public, which in fact is the purpose of zoning regulations, is public safety. So these factors, did I give the black? I don't believe I gave the black. This is what I gave to the zoning commission, and what's interesting in there is I scaled the location of the containers, and included in the plan are the grades and the distances from both the upland review area and the water course. So there's a lot of things that are concerns here, and I finished the notebook with an article from the Office of Legal Research on page 28, where they make very clear that agricultural structures are not exempt from zoning. So I think why the people are here is this is a new use. This needs to have some parameters to it, and if Attorney Zitska is correct in his interpretation, which I do believe he is, then we get another set of eyes to look at this through the planning and zoning, a special use permit. We're not saying that they can't farm. We're not saying even that they can't have tanks, but we're saying it's the subject of a special use permit. Let's regulate this, and I think it will allay some of the fears of the many people that are here. I don't want to take any more of the time knowing the amount of people you have here, but if there's any questions.
Any board members have any questions for Attorney Parks?
Thank you.
All right. Open it up to the floor. If people come up who haven't already signed the sheet, I would ask them to do so as they come up.
I already signed the sheet.
Have a seat.
Thank you.
We don't have a standing mic tonight. But make sure the light's on.
It is, yeah. Good evening. My name is Cheryl Humble, 3 High Meadows Crossing, resident in the neighborhood where these tanker trucks will be traveling. I agree with some of the other statements made, that tonight is not about anti-farming views by the residents, or their right to fertilize, or even the improvements that we see with how it's applied. I'm not opposed to dairy farming. I grew up across the street from Gilbert Farms in Rocky Hill. I am opposed, however, vehemently to the Four Bridges site for continuous 6-day-a-week volume of traffic that will be hauling digestate using 34-foot-long Mack truck tankers, 40-ton tankers, 10 times a day is 1,300 trips over Four Bridges.
I'm going to repeat myself again, what I said earlier.
Yep.
The real question is whether or not the zoning enforcement officer correctly acted under the regulations, and alternatively, whether the right use of agriculture would cover this. If we can address that.
But just let me finish, Chairman, if I may.
Okay.
That the impact on the residents that are directly in the path of these tankers is enormous. We collected 70 signatures in one day for residents in this area concerned about the use of Four Bridges. I have a copy of that petition if you'd like to see it. I have copies of pictures of wildlife on the pond up there. The actual map. Would you like the copy?
With the zoning board.
Again, I wasn't here in January and February to come to these meetings. I come as a concerned resident for 27 children that live in my little community. We're a bus stop. Right where the trucks would turn in, there's a bus stop. The kids are off on summer. They're riding their bikes around this neighborhood. And now we have 1,300 trips by these huge tankers. Thank you.
Mr. Keeney?
My name is Tim Keeney. I'm first selectman and ex officio member of this committee. My concern is the discipline and the focus of this meeting tonight, that we need to focus on, as the chairman said, what the main issue is whether we're talking about storage tanks and that's it. What's out of order is anything that deals with wetland crossings, a culvert, pollution of groundwater, trucks leaking on the road. Those are handled by other organizations, whether it be the Conservation Commission, DEP, Department of Transportation, the local traffic authority. That's what they deal with. This board does not deal with that issue. And I'm just saying that we need to focus strictly on what the issue is, and anything else raised is out of order. That's my opinion.
I quite agree.
Thank you.
And that's why I've asked people to address their remarks specifically to the questions that I mentioned before.
Thank you.
Catherine Mashak, 54 Springfield Road. I have a couple other things, but I'm wondering how often will the tanks be inspected? Who is responsible for that? Is there some kind of governing agency that looks at that? And how is the digestate transferred from the trucks into the tanks?
If this board were to make a decision overruling the zoning enforcement officer, it would be a yay or nay.
Mm-hmm.
It would not be a yay, but you got to do it this way or that way. It would be a yeah, you can, or no, you can't.
I understand, but I believe that those are questions that need to be answered before you can say yay or nay. I am in favor of farming. I have some other concerns that I'm not going to bring up because you have said it's not appropriate. But how the tanks are if you're going to say, I do believe they need a special use permit, but one of the concerns is what's going on with all of them, and who is looking at that, who's following it. I also know that sometimes with a special use permit, there are certain stipulations put on things, and that's followed up, and people have...
Special use permits are issued by the Planning and Zoning Commission,
Yes.
and they do pile stipulations
Yes,
on them all
yes.
the time.
So I'm making that remark because people may not be aware of that.
Okay.
All right? Thank you.
I can't hear anybody because I have a learning disability, even though, not learning, hearing disability, even though I look normal, and my equipment ran out, so I couldn't hear everything that was said by the speakers.
Well, I can't promise I'll repeat.
I'm here as a farm family member. I'm also here as a resident of the property across the street that is currently being used to pour this solution into the ground permanently. And I have a couple questions for the attorney, because I knew nothing about this ahead of time. So, be it. Do you have this process done every single year?
I'm sorry, Mr. Chairman, I think questions go through the chair, and then I'll address all answers.
I can't have my question
I'll answer all at the end.
Yeah, she gets the last crack.
Pardon me?
She gets the last chance after everybody else has spoken.
Do you have this process every single year and every season?
Again, a question to be addressed.
I don't know. I think it's a fair question because I didn't hear it. Again, my hearing. She can't answer it. Okay, that's my questions anyways. Unanswered or not, it doesn't matter.
Yeah.
So,
She's going to answer it later.
later?
Yes.
Yes, thank you. I have my recollection of living at that house across the street. In 1976, I was on Main Street. Property had been bought from Red Howard. And now we have Sonny's Place there. Okay? And I had the birth of my fourth child in 1976, living where Sonny's Place is now. A year later, we moved to the Howard Whitaker farm, which is across the street from that 280-acre field on Four Bridges Road. And I had to look back on my notes on my little machine, and she was saying that the farm was bought from my father at that time. That wasn't in the 76 that they started planning there. When I moved in 77 with my family, it was in the 80s.
Specific year, the question she was arguing that it was
Okay.
of long standing.
Anyways, I was just trying to dispute that. The acre field currently undergoing this thing is done with robotics. And it's something new, like was mentioned before. And I'm just afraid I'm also an environmentalist. We have high water tables there. We have aquifers that have never been...
Again, that's an issue for the Conservation Commission,
Okay.
the Planning and Zoning Commission.
All
Ours
right.
is only on the appropriateness of the order issued by the zoning enforcement
I'm sorry,
officer.
but I didn't hear everything, and it's difficult. Thank you.
Hello, my name is Seth Taylor, and I'm with Oak Ridge Dairy. My family has owned it for The family has owned Oak Ridge Dairy for 5 generations, and I think it was late 70s, early 80s. I don't know exactly looking at the deed. We owned it with the Moser family for a time. The reason I guess I wanted to add is currently we use a transfer tank that we've done for the past 5 years. That we park on the side of the road, one of the same exact tanks. We park it on the side of the road, and we use the same trucks to come up and put it in those tanks. Transfer tanks. It's in there for a couple minutes, an hour, it transfers through. There is no difference of this application is what we're currently doing now. We have one transfer tank, we bring the truck up, we transfer it, and what they're saying is if we park a tank overnight, we need a permit. And that is wrong. And that's why we feel that we do not need a permit. It's regulating a practice that is farming and is going to hinder what we do. If we want to move it to the other side of the field, we're going to need another permit. If we move this tank multiple times a day or during the process, we have a tank that's parked on the side of the road, we transfer into it, and it's empty by the end of the day. There's no difference of what we're doing today, and we will continue to do if this doesn't go through. We will continue to do that. We will be up there in a couple weeks. That is not changing. It's just asking, we want to put another tank or 2 tanks next to it. It will be filled in the morning, and it will be empty by the end of the day. It's like, to the school bus analogy, I want to say, would you say a school bus is a storage? No, it picks up kids, it goes to their house and drops them off. It's the same thing. It's not a storage. And in New York, storage is defined by 7 days. In Manure, New York is ahead of us. In our regulations, unfortunately, it doesn't have that spelled out, but we're talking a matter of what went in today will not be there tomorrow. That's all I have to say.
Quick question.
Yeah.
You guys were before the Planning and Zoning Commission in February, weren't you?
Yep.
And gave a rather detailed explanation of this.
And they did not make a determination?
No, they asked for a legal opinion.
Yep.
And all I'm saying is, if it's a question of a permit, permits get issued by the Planning and Zoning Commission, not us. All we're doing is deciding whether in this instance, the zoning officer correctly interpreted the regulations, or more to the point, whether she incorrectly did.
And we feel like it's incorrect.
Thank you.
Oh, Ralph, I was just going to ask him a question if I could.
Yeah, go ahead.
You'll be next.
The number of tanks and how long they will be on the property.
What's that?
Could you tell me the number of tanks and how long they'll be on the property?
4 tanks.
Left there
Through the season.
through the season.
Yep.
So you don't need a permit if you pull your truck up to the side of the road and either pump it out from the truck or spray it from the truck. My opinion is that you are leaving tanks there for an extended period of time and you need a special use permit. And you don't need to get one every year. It's just for what Mr. Attorney Ziska had explained. So just for a point of clarification.
Yeah, but that like, how long?
I just wanted to clarify. Thank you.
You're up.
Good evening. My name's... Can you hear me? My name's Edward Moore, and I live at 346 Springfield Road. I've been a resident of this town for 17 years. My thing is, if they want to put permanent storage tanks, Mr. Baylor just said that they have their mobile tank. Why do they need permanent? And then they're saying it's going to be filled during the day and empty by night. I see the trucks all the time. I think what it is, they're just trying to pull a bruise. I say, no, not in our town. They want it, let them do it in Ellington. If they can move their mobile tank as much as they want. They don't need a permit for that.
As I said before, the question here is not whether they're going to spread manure. They are going to spread manure because they can. The question is whether or not these tanks are allowed without a special use permit.
Correct. I'm sorry, I digress. I believe that the tanks will be permanent. They will be filled all the time. They're not doing where they're going to do whatever they're going to do every day. It's going to be a one and done as far as I understand. So I think what they're doing is just trying to pull an end run. Thank you.
Thank you, sir. Anyone else?
My name down. So, but my wife and I.
Why don't you state your name for the record?
Sorry, my name is Marco Campelli. My wife and I own the property on the corner of Durkee Road and Fort Bridges.
State your address, please.
240 Durkee. It's a building lot still, so we haven't built it yet.
Pull the microphone a little closer to.
Sorry. Yeah. So we'll be directly downstream of this. If anything goes wrong, I personally would feel most comfortable. This is purely anecdotal.
Again, we're not dealing with water issues.
Say again?
We don't deal with groundwater issues.
Right. In terms of, but the additional oversight to pursue a permit, I think, would make me personally feel most comfortable. So.
Okay. Anybody else?
Recess for a few minutes because we need to recess.
Could take a momentary recess.
Sorry.
Make yourself comfortable in it.
Yeah, there you go.
Did a great job. Yeah, it was amazing.
I gotta ask.
I think that's a sound. If you took it down. So that's why they don't. That's why it's not letting you have any more cows. That's right. Talking about just 250 more cows. In Ellington, I guess, yes, it is.
Are we ready?
Permission to reconvene? Mr. Teasing?
Hi.
Identify yourself, sir.
Sure. My name is Robert Teasing. I live at 12 High Meadows Crossing in Summers. I happen to be a veteran. My wife and I are here as residents of Summers and High Meadows Crossing to support the decision of the zoning enforcement officer, Jennifer Roy, to require Oak Ridge Dairy LLC to get a special use permit for their plan to dump and store its waste in Summers. Now, Oak Ridge Dairy LLC is a big business and requires limits and monitoring of the limits placed on it for it to do business in Summers. These limits are to protect the environment in Summers, and the tanks that are going to be storing this distillate could possibly leak. And I don't know if anybody's brought up how they're going to get these tanks to the property and the location that they said that they're going to put these tanks. Supposedly,
You've already addressed the one issue is actually before the board tonight.
Right.
Whether you support the decision.
I do support that. I also was going to say that, we live at High Meadows Crossing, which is a subdivision built by Mike Layaska, and approximately 2010 to 24. And there are 20 houses in our subdivision, which runs along both the sides of High Meadows Crossing and sides of Four Bridges, one of which borders on Hall Hill Brook. And I think one of the reasons that we're concerned with the safety of the water is because of the storage tanks. And if these storage tanks leak, then it's going to affect the water. And so, as they mentioned, that one of the things that the Planning and Zoning Commission have to deal with is safety. So, the attorney here said that the regulation of storage in 1990 was to protect groundwater and wetlands. She was talking about the horse manure and the cow manure. Well, not the cow manure, it's just the horse manure. But the reason for this regulation change was because of this, protect the groundwater. So we are concerned with the groundwater from these storage tanks.
But again, that's not before this board tonight.
No, it's the storage tanks that are for it. But what is the reason for the storage tanks, and why would people be opposed to it? It's because of the safety, and they're concerned with the groundwater.
Okay, thank you.
Okay, well, thank you.
Anybody else? If not, I'm going to give Attorney Reiser last licks.
Okay, thank you. There's a few things I want to follow up on. The zoning agent said this is really about the tanks and not necessarily that they're storing manure, but just the tanks because they're going to be left there. Is that correct?
Let me clarify. I said I'm not questioning the difference between manure or digestate.
Okay.
Or the fertilizing of the fields.
Okay. So then what this really comes down to is whether or not you interpret your regulation, I'm trying to find the regulation, excuse me. You interpret your regulation, manure storage, to govern these tanks. Manure's on site now, manure will be on site later, manure has always been on site and will be used. So it's really about these tanks. And Attorney Parks had said, well, agricultural structures aren't exempt. I agree. I'm not saying agricultural structures are exempt, but you have to look at what the regulations provide for. Your regulations with regard to agricultural structures really talk about setbacks. Again, we don't contemplate, just because it's a tank, we don't contemplate this to be manure storage because we are not bringing the manure to the site to store for any indefinite period of time. It is a transportation facility. It is a vehicle to move the digestate from the truck to the Rain 360. There is, and I've already discussed this, your regulations permitted as of right say agriculture and farms. Farms include farm buildings and other structures or temporary structures used in connection with the farm. And structures is specifically defined to include buildings, manufactured homes, paved areas, storage tanks. So storage tank. A storage tank, if we're really just talking about the tank, and it's used in connection with a farm, is a permitted use under agriculture and farm. Okay? That's what your regulations say. If you want to deem that a conflict with storage of manure, then you have to find a way to reconcile them. And I think I gave you a very plausible way to reconcile them. I think that this regulation was intended to deal with something other than manure being brought to a site for fertilizing crops. It was intended to deal with manure generated from animals on the site. So if you look at it solely from a structure standpoint, setbacks, things like that, your regulation, that's fully complied with. Now, what it really boils down to is it manure storage in that structure. If you're going to determine that it's manure storage because it's a tank, you have to look at manure storage whether it's in a tank or not. If you're going to single out this farm and say, because you're storing your manure in a tank, you are regulated as manure storage, but if you're storing it on the field, you're not. And every farm in Summers is storing manure on their fields, and I bet you it's in excess of 16 cubic yards. Look at the other farms around. I don't want to call anyone out by name, but there are a lot of farms in Summers, some more recently building barns, and there is manure in excess.
Barns.
Is there a manure storage permit?
No.
You know what? I'm not don't mean to grill you. So I'm just.
This is a bin right on the road. 4 bins right on Hurlburt Road, right up against the road.
But the bins, the storage tanks, really isn't the issue. It's the manure storage. It's not the tank, and the tank complies with all setbacks. We're not talking about keeping it on the road. We're talking about keeping it well into the property, which is why we got the wetlands permit to do the driveway and the culvert crossing. The requirements in your zoning regs for placing of the structure, the agricultural structure, those are all complied with. The real issue that this boils down to is, does this constitute manure storage? And again, if that would be manure storage whether it's in a tank or not. And if you're going to say it's manure storage because it's in a tank, you need to say it's manure storage on every other farm in town. And we'll be looking at that. We will be wondering if you are singling out this farm and treating them differently. I don't want my clients to be looked at as trying to hide from regulation. But you know as well as I do, based on everything we heard tonight, if they submit to planning and zoning for a special permit for this, when we still maintain and believe it's a permitted as of use right, they're going to have a 3-ring circus in front of planning and zoning, and they're going to get every condition you can possibly imagine on that, which is going to make this most likely cost prohibitive. What we're going to end up doing is probably having to build a facility, kind of like the facility we were here trying to build a year ago with the irrigation pond. And it will, if we have to design this as some type of a permanent storage structure, it's going to be some clay-lined pond that's designed by an engineer, and it's going to be like what nobody wanted, which was the open irrigation pond that we had talked about a year ago. We are doing something different. We are not doing this as a permanent storage structure. This is a tank that facilitates movement of a liquid fertilizer, a liquid manure, from truck to sprayer. That's it. And as Mr. Baylor said, what's there tonight is not going to be there tomorrow. It's a conveyance system. It's a piece of equipment in connection with the irrigation and fertilization and the broadcasting of the manure on the fields. So we don't maintain and contend that agricultural structures are exempt from zoning. We just say we're compliant with zoning. We also say it's permitted as a right as part of the farm, and it is not manure storage, because it's not manure storage for any other farm in town. So based on that, we don't see how you can require a permit from this farm just because they want to hold their manure in a tank versus plopping it in the middle of a field like they used to and that all the other farms do. I think that that's an extension beyond the power of the regulations to require that.
That's the way it should go.
If you want to be concerned about Section 7.12 and the regulation that talks about plans for new and enlarged manure storage sites, again, we don't think this is a manure storage site, because it's a farm, and we're not storing manure there, we're just applying it to the ground. And again, if you want this to apply to us, it applies to every other farm in town. So then you're going to have to say every other farm in town, before you can store manure on your site, you're going to have to apply to DEP and Department of Ag. By the way, DEP, we have all of our permits, and we have our Clean Water Act permitting, our CAFO permit that ensures compliance with the United States Department of Ag. And it says you have to apply no later than the day of submission of any application for a zoning permit for the site. So might you consider, well, you need a zoning permit maybe for the tank just to establish that it complies with setbacks. And so apply, which my clients have all of their approvals in place anyway, but that still doesn't require a special permit, right? There's nothing that requires a special permit for this tank that is being used for the dissemination of manure fertilizer on a crop field. Okay? That is the biggest distinction here. We are not trying to skirt or anything. We're trying to prevent my client from having to do cost-prohibitive measures in connection with fertilizing their fields that no other farm in Summers has to do. I think that the regulations are extraordinarily clear in your definition of farm, in your definition of agriculture, both with regard to cultivating the soil being the use of manure, and the temporary structures allowed on a farm that are in furtherance of any farming operations, which is the spreading of manure. And as long as those structures comply with your setbacks and your regulations, and I went through your regulations. All of your regulations on accessory buildings have to do, again, with setbacks from the road, especially if they're housing animals and things like that. There's no evidence of violation of your regulations with regard to setback and bulk standards having to do with these storage tanks. The only question is, does the storage tank somehow make this manure storage when it wouldn't be manure storage if it was just dumped on the ground? I don't see how you can reach that. I don't see how the containing it in a steel container for dissemination of the liquid is going to be treated differently than dumping manure on the ground to be spread on the fields. Thank you for your time.
Further questions for the attorney's advisor?
Follow-up question. Is there any other farms that have these tanks in Summers today? You brought up other people, what they're doing.
The only farm that I know that has these tanks in Summers today is another farm owned by my client. That's not the subject of this appeal. Are you familiar with any other farm? But that's because not every...
other farming, so I want...
Yeah, no, and the reason, that's an interesting point, is because in order to get the digestate, you need an anaerobic digester. And I'm not sure that there's a lot of other farms that have gotten there yet. So it's a modern type of farming. Your definition, not only your definition, the statutory definition of farming is broad. And the reason it's broad is because farming is always changing. It's modernizing, it's changing, it's evolving, it's growing. Farms grow. And you need a dynamic definition that goes along with it. So that's why your definition, and the statutory definition, is so broad. And because it's so broad, it includes our ability to change with the times. And this is just, all we're asking for is to continue spreading manure. And now we need to use this structure to help with the fertilization process. As a vehicle to spread the manure, we need it to go through here and into the Rain 360 to then be broadcast onto. And we believe that is entirely within your definition of farm and agriculture and permitted as of right. We thank you. I know you've heard a lot. And I just hope that you will. It's not a numbers game. It's not how many people are in favor and how many are against. It's what the regulations say, and it's up to you to decide that. Thank you.
Ralph, can I say anything further
Yes.
for the record? So further clarification of my view. My opinion that I provided Oak Ridge and Attorney Reiser was that both locations required a special use permit. The bins that are already on Hurlburt, which were put there unbeknownst to me, are not in compliance with any setback regulation. They're right on the road. So whether it's an accessory structure, which can't be forward of the building line, or the house on a property is at least 50 feet, and any storage of manure is 100 feet. I happen to have issued a cease and desist a few years back to someone on Billings Road because they had their manure pile right on the property line, and there was a house in very close proximity. She moved it. So I just wanted to clarify those things. I'm not singling out. This has nothing to do with spreading manure at all, with that. Farming, fertilizing, nothing to do with it. It has to do with the structure, the number of structures, and further, Grower Direct, years back when I first started, they put the greenhouses on Fort Bridges Road. I told them that they needed a special use permit. They didn't agree because it was agriculture. Well, it's a commercial operation. Fort Bridges is a commercial operation. They're trucking out plants. And the purpose of a special use permit is to set parameters for everyone involved. When the hours of operation, which I'm not even questioning the hours of operation for this, I'm stating that the PZC needs to approve the location of the tanks. That's my view. That's my opinion.
Just a couple of points, and I'd rather say it now before the hearing is closed, even though theoretically I could do it after. If you take Attorney Reiser's argument literally, I'm looking at the definition of agriculture, and that includes the production or harvesting of maple sugar, or maple syrup, or maple sugar, or any agricultural commodity. So the production or harvesting of any agricultural commodity as an incident to ordinary farming. And then you look over at section 3.3, and you look under the residential A zone, and buildings on a farm for storing or processing agricultural products not allowed. Buildings on a farm for storage and repair of motor vehicles and or equipment for operation of such farm not allowed. If the intent of the broad definition of agriculture was anything goes if it's related to agriculture, these provisions would make no sense because they're within the definition of, they're literally within the definition of agriculture, and yet the Planning and Zoning Commission said no, not in the A zone. No. So you have to look at the specific type of incidental or accessory uses that we're talking about to decide whether or not it's allowed. Agriculture as a general principal use is allowed, but specific aspects of an agricultural use can be separately regulated, and that's what we think the Zoning Commission did.
With that,
Final comments? With regard to...
This is not a tennis match.
I will end there.
Final comment. With regard to Hurlbut Road, I can certainly talk to my client about the placement of those tanks, but the issue remains the same. Is this manure storage simply because it's in a tank? The tanks have to be compliant. So if they're not compliant on Hurlbut, we'll figure that out. But the tanks have to be compliant. And yes, you can regulate an ag structure, which includes a temporary structure on a farm. But that's different from is this manure storage? I'm not challenging whether a tank is a farm structure. I agree. A tank is a structure. It meets the definition of a structure, but does it meet the definition of manure storage? I don't believe it does. I don't believe this is manure storage. I've said that a million times. I believe the regulatory history shows that this wasn't intended for this purpose. I also believe that the intent of manure storage does not apply to farming and to fertilization and cultivation of crops and fields. Thank you.
I'll entertain a motion from the board to close the hearing.
Make a motion to adjourn.
Second by Mr. Sevens. All in favor? All right. The hearing is closed. Now the question is, the next item is discussion, possible decision on this application. Do you feel on one hand, we've received a lot of material tonight, which we could spend time digesting. I also happen to know the chances of having people we've got here in the same room again in the next few months might not be till August. I personally am comfortable with moving ahead. If anybody uncomfortable with that notion, then I will entertain a motion to approve the appeal of Oak Ridge Dairy, ZBA 26-001, appealing the zoning enforcement officer's order regarding the storage of manure. Just for the record, folks, that's how we do it, as an affirmative. Do I have such a motion? Mr. Stebbins, do I have a second? Ms. Moody? Discussion. Okay, since everybody's shy, I'll start. as I said, maybe ad nauseum tonight. The question before us, as I see it, is whether or not the zoning enforcement officer properly looked at the regulations and made an order consistent with the regulations. Some of you may know that in a previous application, which as it happens involved the same property and the same applicant, we overruled the zoning enforcement officer. And it was over storage of manure, because that regulation, through whoever fault, I think was overlooked. I don't think it is overlooked here. I think Attorney Ziska correctly brings up the issue of capability, regardless of intent. A tank that can store will be used for storage at some point, or you have to assume that it is likely to be used for storage. It's the camel's snout under the tent. I'm sorry, folks. And nothing, as I said here, is meant to suggest that agricultural use is not allowed as of right. As I said, cautioning comments, manure is going to be spread. The question is not even a question of how it's going to be spread. That's not even for us tonight. For us tonight is this order. And I think, frankly, Oak Ridge recognizes this because they did go and gave, I thought, an enlightening presentation to the Planning and Zoning Commission in February about how this would work. I was enthralled. But that's not our perspective. That's not our say. And I would, as I encouraged them in October, when the lagoon was shot down, I would encourage you to go to this Planning and Zoning Commission. They seemed, by the way, quite receptive to the idea. And yes, they're going to set some parameters, but you're going to get your way in one way or another. But we're not going to get it by us overruling the zoning enforcement officer, at least not if my vote carries. That's my piece. Anybody else?
Can I say something just administratively? I just wanted Ralph to explain to the new members how their vote would affect the motion to grant the appeal.
Okay, a motion of aye is a motion to grant the appeal from Oak Ridge Dairy. A motion of no is not to grant the appeal and effectively to uphold the zoning enforcement officer's order. Any further discussion? Can we move to a vote? All in favor? Okay, Mr. Stebbins votes aye. Opposed? I vote no. That's 3. Do you care to vote?
Yeah, I need to vote. Yes. Yeah, you're seated tonight.
Okay. It's up in the air, honestly.
What'd you say?
It's up in the air.
I will give you the option of abstaining because the fact of the matter is that for the appeal to be upheld would require 4 affirmative votes, and they already have 3 negative votes.
Well, then I'll abstain.
Okay. Mr. Wheeler abstains, so we have a vote of 1 in favor and 3 against, and so the appeal is denied.
Thank you for your time.
Okay. Thank you. I see them all the time. I live on Route 83.
I'm surprised.
Oh yeah. Well, you know that used to be the
Okay, we're going to go to the small
field on Springfield Road. On the right. Well, that's behind my house.
I just told Rob that I told
Why, like,
Yeah.
Teasing.
I own 4 properties now. I think the house
No, I see the tanks.
I would ask that meeting. I live in Great Grove, and I own 3 properties.
Yeah, well, that's not still have a meeting. We haven't adjourned yet. Go back and do Excuse me, please, folks. I would invite you to take your conversations outside. We have a meeting to continue here.
For you,
Okay, the next item on
this is good. Because you come to a lot of meetings.
I'm all your list now. Nice to meet you too. I've always admired your house, but I've never seen you.
Sorry, it's just this mic picks up all your voices.
This is what they have.
Thank you. A little bit more involved. It is for 36 years.
Okay. Okay. Moving to our next item on the agenda, item G, discussion and possible decision, Attorney Ziskas and Ms. Roy's recommendations for zoning, ZBA regulations versus zoning rules. You all received a copy of that?
People with their streets can't hear. Sorry.
Any discussion? Well, first I'll make it easy. I'll make a motion to adopt the proposed ZBA rules that have been proposed by Attorney Ziska and Ms. Roy. Do I have a second? Okay. Any discussion about the provisions?
No.
Okay. Everybody's had a chance to look at it? All in favor of adopting the ZBA rules, say aye. Aye. Passed unanimously. Okay. The next item is the minutes of the February 19th meeting, which I believe you've all received. Any questions about the... first I'll entertain a motion to...
Make a motion to approve the minutes for February 19th meeting.
Okay.
2026.
Do I have a second? I want to chat with you for... I don't think you can because you weren't there.
He wasn't here though, so who's going to approve that? He wasn't here.
It's just like administrative.
Okay, that's fine.
She's not granting anybody anything, but you're saying the minutes.
She may have still read them, and they may have still looked at them.
Nobody had any questions about the contents?
No.
All in favor?
Aye.
Aye. No opposition, passed unanimously. And then that most contentious issue of all, motion to adjourn.
I'm going to second.
You make a motion, you second, all, that is not subject to debate, all in favor?
Aye. You can vote on that.
Why is that always the motion that gets everybody so excited?
Meeting